Joanne, if you get a message from me, please ignore it.
Okay.
Is my audio on, Joanne?
We can hear you good, Mel.
Thank you.
That's terrible. Better.
So by my clock, it's 5. I don't see James. Oops. Is James here? Jesse, do you know what's going on with James?
I don't see him yet.
Okay, I'm going to wait just another few minutes so that we can get our town attorney online. Thank you.
He's logging in now.
He's on, Joanne.
Okay, I'm told James is with us. I don't see him on my screen.
He's signed in, but I don't see his face yet.
Ah, there you are. All right, James, we can only see half your head, so if you want to tilt your camera a little bit, if you can hear me. James, can you hear me? James, can you hear me? Can everybody else hear me?
Can you hear
I
me?
hear you fine.
Okay.
Yeah.
James. Jesse,
Maybe you should enable chat for a second and send him a chat. Just tell him we can't hear him.
Yeah, I can send him one.
that'd be good, Jesse. Thank you. Looks like he's had a hard day.
I'm just curious, can I put a picture of somebody about 30 years younger than me on here?
Only if I can.
Sure, absolutely. I'm with you, Joanne.
James, can you hear me?
Yep.
Oh, is that a yes?
Can you hear me?
Yes.
Oh, finally, yes, okay.
I was
I
having
am
trouble
now-
with my speakers.
Okay. All right, I think everybody can hear everybody that needs to. So I'm going to call the meeting to order. Board of Appeals for the Town of Tremont is hereby called to order. We'll start with roll call. I'm Joanne Harris, Bass Harbor. Mel?
Mel Atherton, Bass Harbor.
Mike?
Mike Hayes, Bass Harbor.
Rick? Muted, Rick.
Sorry, Richard Cohn, Cape Road, Seal Cove.
And Marcia?
Marcia Madeira Bernard.
Thank you. I have determined that we have a quorum and we can proceed. Any adjustment or can we adopt the agenda, which is to continue our meeting from April 14th as we make a final decision on the administrative appeal from the concerned Tremont residents.
So moved.
Thank you. Any discussion? All in favor, raise your hand. So we have adopted. Marcia, I might have to have you turn your face on for me.
My hand is up.
Yeah, but we don't see you.
Oh,
There you are.
Hey,
Okay, your hand was up. So it's unanimous. We are going to move ahead with the agenda.
Joanne, can
Yeah,
I interrupt with one quick housekeeping thing?
please.
The lady that types the minutes for the Board of Appeals and the Planning Board, she watches the videos afterwards, and it only shows speaker view, who's speaking. So she's asked that when a motion is made, if you could repeat who made the motion and who seconded it, just so it's accurate in her minutes. And then if there's any time, such as adjourning, that you state the time.
Okay. Well, I would say we started the meeting roughly at 5:05, give or take. I'm not sure who made a motion to adopt the agenda.
I did. It's
Thank you,
Mike
Mike.
Hayes.
I think,
I made the motion.
thank you. That's Mike Hayes made the motion. Rick, I think you seconded the motion, and
Okay,
it was unanimous. I saw your hand go up, so. And it was a unanimous vote.
Thank you.
Okay, no problem. And Jesse, please jump in if I miss one of these because I may forget to do that.
Yep.
Okay, so just as a reminder where we left off, we had asked James after his vacation to please provide us with some information, not only drafting of findings of fact for us as we come to our decision, but to please explain to us the difference between vacate and remand. James, I want to thank you. I think you did I read it and I pretty much got it all. And I know bringing this stuff down to lay terms is not always easy. So I appreciate all the work that you did.
It's not easy to do that either. I spent a lot of hours writing and rewriting it to make it look simple.
Well,
Thank you.
I know
Thank you.
having worked in a scientific organization, I know how difficult it is to bring some of that language down so that everyday people can understand it. So I can appreciate the work.
It's better to go right back to the dictionary. I think that works best.
Yeah, that's where you started. That was helpful. Yes,
Yeah.
Rick.
one of the things that James pointed out in his memo was that we never acted on one of the objections, which had to do with the due process in the hearings before the planning board. He's right, we didn't do anything about it, and I don't think we should. I think we've disposed of or about to dispose of the matter in other ways, and I'm not sure we have jurisdiction to decide constitutional stuff anyway. But I don't know whether to just leave it as a hanging Chad or James, should we do something about it to close it out?
James, do you have a
Yes, I do. The answer generally is you should never leave anything. You should always decide on everything. So I was hoping that you just go through it quickly and
Do you think we have the constitutional jurisdiction?
I don't know, what's the question?
The the matter that you said we had left hanging was
Right.
whether or not the objectors had been deprived of due process of law as a result of the way the planning board.
Oh, no, you're right.
conducted the
You're
hearing.
right. No, we don't do with that. That's,
Well,
you're right.
that's,
That's
I agree with you.
constitutional.
So
But I
I
think
agree. So what did we do about it?
the board says we have no jurisdiction over that, move that that's not something for the board to address and vote on it that way. You get a motion that it's not within your jurisdiction and then you vote on it.
All right, how about if I make such a motion that we not decide the due process issue on the grounds that we are not legally competent to do so?
I like it.
I second the motion.
Thank you, Mike. Any discussion by board members? Hearing none, seeing none. All those in favor, please raise your hand. All those, well, yep, that's unanimous. So Rick made the motion to not deal with the due process question. Mike seconded that, and the vote was unanimous in favor of that motion.
Madam Chair, can I get at you for one little housekeeping thing?
Yes.
I think it's appropriate before you get too far down the road to just say that this meeting was not advertised because it was a continuation to a date certain, and to say that you continue to believe that the board has jurisdiction. It's an ongoing matter and you decided on jurisdiction last time. And as far as you know, or you should ask the board members whether there are any issues of bias or conflict of interest that have arisen magically since the last meeting.
All right. So with those cues, this Board of Appeals meeting, which is, by the way, a closed meeting to just members of the board. This is not, it's in the public eye, but it is not open for public comment. We have not advertised this because it was a continuation of this case. We continue to believe that we have jurisdiction in this matter. And by any chance, does any member of the board believe that they have a conflict of interest in continuing with getting to a decision on this matter? Seeing none, hearing none, I'll presume that there is no conflict of interest. Okay. So I don't know, board members, if you'd like James to briefly walk us through the differences, if you have, or if you have specific questions between, I know I do, between remand and vacate. So I'll open it up to members of the board for any questions. Go ahead, Rick.
I understood from their submissions that both counsel, Mr. Hamilton and Ms. Chow, agreed that reversal period was the appropriate way to go. So I don't know if we have to go into the details.
I believe that's correct. And, you know, that is something we should factor in. It's not automatically a determination of how we want to proceed, but certainly it's for different reasons. I think both sides have come out to that conclusion. But I had a question on that, unless another board member has a question. So, James, my question is this. I marked it here. As I read through your document of the memorandum, vacating versus remanding, it sounds like I'm in the middle of page 2 of 4. In the Tremont land use ordinance, the term vacate is not used, but land use ordinance, Article 9, Section B, so forth and so on, states regarding the term remand, planning board decision appeals. If the Board of Appeals determines that the records of the planning board proceedings are inadequate, the Board of Appeals may remand the matter to the planning board for additional fact finding. Then it goes on to say, planning board decision appeals. The Board of Appeals may reverse the decision of the planning board only upon finding that the decision was contrary to specific provisions of the ordinance or contrary to the facts presented to the planning board. In thinking about our first issue, which was that road that was part of the evidence, being the one road in and one road out, which incorporates Acadia Wilderness Village, I don't know that there's any specific ordinance that was in violation there. It was more inadequate, in our opinion, there's more inadequate information that the planning board should have pursued that, in our humble opinion. And that suggested to me that's more of a remanding, rather than a specific ordinance that they violated by or ignored.
Right.
You see where I'm coming from?
Yeah, yeah.
Okay.
So I think the remand is sort of an interesting concept, the way it's stated in your ordinance. Inadequacy. It's fascinating, isn't it? Because the standard on an appeal is so high. The planning board would have had to have basically screwed up the law. They were wrong on the law. And the Board of Appeals says, no, that's not how you interpret that. You interpret it this way. That's what the Board of Appeals can do. And then the other way the Board of Appeals can do it is there's absolutely no evidence that any reasonable person would look at and decide otherwise. I mean, that's a really high bar. So if the board would got inadequate evidence, in other words, they didn't get any, or damn near none, then obviously you'd have to remand to fill in. So the concept of remanding and ignorance would go together, right? It's fascinating. It's exceptionally rare because, especially here, I mean, I think it was Ms. Chow said it was 1,500 pages and went on for 6 months. The idea there was a lack of information on anything is hard to believe. As to the terms, I wouldn't get too hung up on them. And frankly, before you get too deep into this, I just want to say, don't remand. I studied this over 2 days. I did nothing else, as the billing will reflect. I did nothing else those 2 days. I just stayed in my cave, got my head down, smoked several cigars, looked at the term remand versus reversal versus vacate, looked at a lot of case law, looked at the MMA manual, and when I was finished, I was convinced that it was an absolute nightmare if you remand. You're in I said quagmire in the memo, you're just in hell. And both parties, for apparently, I think, opposite reasons, want you to, if you're gonna, Mr. Hamilton wants you to affirm, but if you're going to decide reverse, you can reverse and remand, or you can reverse and vacate. They both want you to vacate. So if you're going to reverse, they both want you to vacate. Now, if I was you, why tie yourself up in knots? They both want you to vacate. So if you're going to reverse, vacate. That way everybody's happy, and you don't leave the planning board with an unholy mess. I couldn't figure it out. I was tongue-tied, and usually I'm not at a loss for words. But at the last hearing, do you remember I just said, I don't know what's going to happen. I spent 2 days looking at it. Man, it didn't look good. There just seemed to be a lot of blind alleys. and a lot of, I don't know what's gonna happen if you remand it. Because, you know, it got to, well, you're gonna need more information. Well, does that mean you're gonna force the applicant to submit a new application, including both sites? I don't know, is that fair? There were all these questions that were really difficult to answer. And the more I thought about it and the more research I did, the worse it got. And I've been doing this for a couple of decades, and I'm usually not stumped like that. And then it never got better. So my advice to you in the strongest possible terms is, if you don't want to affirm, and if you before said you wanted to reverse, don't remand, vacate. By the way, I don't know about you guys, but somebody on an iPhone has got a red screen that's flashing, driving me nuts. Ah, there she is. I see her.
So, James, I have one follow-up question. If we were
Yeah.
to reverse and vacate,
Right.
are you satisfied you could write up the findings of fact and tie it appropriately to?
I already did. I already did.
All right, okay.
I mean,
Okay.
I kept it nice and simple,
Great.
right?
Yep,
In fact, let me just have a quick look here. I did it.
you're right. I remember now. You did it for both. You do it.
Yeah,
either
just
or.
scratch out one of them and go with the other.
Gotcha. Rick, did you have a question?
No, I was just going to say, I agree with Mr. Collier completely. And I think we have to be, any adjudicator has to be careful when everybody before him agrees on an outcome, whether it's for the same reason or not. And all of the funny little blind alleys that the poor planning board would have to go up if we remanded this to them, it would be awful. I have the same reservations James has.
Madam Chairman,
Yes, Mike.
you know, we already decided in the previous meeting that there were at least two of the appellant's arguments that we accepted. So I think our ability to say that everything's fine isn't working. We have both parties who would like to see us nullify that decision. I think we would be well advised to make a motion to nullify the planning board's decision and let it play out from that point forward. It is complicated and ugly, and I don't see any good way out of it for either the appeals board or the planning board.
Okay. Any other discussion? I will entertain a motion at this point from a board member.
I'll move that the Board of Appeals upholds the appeal, reverses the decision of the planning board, and vacates that decision.
Second.
Mel Atherton moves to uphold the appeal, reverse and vacate. Rick seconded the motion. I'll call for a vote. All those or any other discussion? All those in favor, please raise your hand.
Could you do a roll call vote, Madam Chair?
Yes, thank you. All right, I will do a roll call vote. Mel, how do you vote?
Aye, yes, Mel Atherton, Bass Harbor.
Mike,
Mike Hayes, Bass Harbor, aye.
Rick,
Yes.
Marcia. You're muted. You're muted. Can't hear you.
Can you hear me now?
Yes,
Yeah,
I vote aye. I'm from Bernard, Marcia Madeira.
thank
Bernard,
you. And,
aye.
and Joanna Harris votes yes. So it is 5-0, unanimous decision. Okay, we have findings of fact that we can now choose the one that vacates the planning board's decision. Jesse, looks like you need signatures. Do you need signatures from everybody to stop into the town? You do. Okay. So board members, this will be ready when, Jesse?
Uh,
Tomorrow, it's fine.
Really? Okay. Yes, Rick?
We haven't adopted the wording of the draft that James sent us, and I have some things to discuss about it. There
Oh.
are not many, and they're not intrusive, but I think they're worth considering. And I don't know whether I'm supposed to make a motion or what, but now seems to be the time to deal with them.
Yeah, no, you're absolutely right. So you all have a copy of the statement of findings of fact and conclusions of law. Rick, do you want to share with us the parts that you'd like to see changed?
Yeah, let's see if I can find where I should start. Can I say something before I start that? The parties to this might consult a case called Silsby, S-I-L-S-B-Y, against Allen's Blueberry Freezer. It's a 1985 opinion of the Supreme Judicial Court of Maine talking about resubmittal of applications which were once denied. And I'm not going to tell everybody what I think it says, but it's worth both of them looking at. I think they're all three of them. Anyway, let me find where to start here.
And while Rick is doing that, did any other board member have any edits for the findings of fact and conclusions of law?
I
Yes,
do.
Dan?
I just wonder, because I'm trying to fix it right now. Did you have that, did you write that down quickly? It's so hard to do it. On the motion in regard to the due process thing, can you just tell me what that was again?
Jesse, do you have that?
I was jotting it down quickly. It was a motion to decide the due process. The board would not decide the due process on the grounds that you don't have constitutional jurisdiction over it, over the matter.
Actually, it was on the grounds that we are not legally competent to make that decision.
Yep. Okay.
Did any other board member have edits or suggestions for findings of facts? Okay, so Rick, did you have any
Yeah.
issue with the findings of fact?
Well,
Madam Chair, before anyone else goes, I will have an objection if the board is going to go back through and edit all the findings. My concurrence on behalf of AWL with the proposed remedy was based upon the findings crafted. I've already entered my objections, but I would enter the objection that we shouldn't be amending findings unless we're going to have the opportunity to comment on the amended findings.
I think we've had a lot of comment from council. And the matters that I'm going to bring up are not ones that they haven't already attacked from various points of view. I don't, do what you want. The first thing I have a problem with is on page 3. At the top, it says that the Board of Appeals is charged with hearing appeals from decisions of the planning board solely as an appellate body, which is fine, considering only the record made by the planning board. There's a problem there because the fact of the matter is, I believe we have gone beyond the record made by the planning board. And I think we've done so legally, because I believe the doctrine of judicial notice applies to this agency. And I think that's what we did. And Andy thinks that's great. And I can see he's smiling. He's got another issue. I'm really talking now to a court that's going to review this. I have a 3-page memo analyzing the problem if anybody wants it. And the issue I'm talking about is a nationwide issue that every court in our country deals with. It's evidence 101. I think that saying that we considered only the record made by the planning board, it simply is not true. We considered the fact that changes were made in the village that were not reflected in the planning board record. And I believe that we had every right to do so. I don't believe that we have to pretend that things that everybody knows happened and pretend that events and documents in our own board records don't exist and make a decision based on self-imposed ignorance. The village is not what it was when it was approved, I'm sorry. Whether the differences are gigantic or minuscule, you can argue that forever, but there are differences. And one of the reasons that we're unhappy about the fact that the planning board dealt with the lodge to the isolation and to just blocking out as though the village didn't exist, is that it does exist, and everybody knows it exists, and everybody knows that the two operations can have impacts on each other, and everybody knows that what happened to the village between its approval in 2019 and the summer of 2021 might be significant. And the only people who can tell us whether those changes are significant or not, my computer is making funny noises. The only people who can tell us whether those changes are significant are the kinds of experts who testified on both sides before the planning board, but didn't focus on this problem. So you can do whatever you want with that. Okay. Just below the middle of that same page 3 is a conclusion of law. Why this is a conclusion of law is beyond me, but it's a conclusion of law that the planning board conducted an intensive review of the campground application over a period of over half a year. They held numerous meetings and public hearings. They required comprehensive expert opinions from the applicant, AWL, and they had their own experts review much of the evidence presented by the applicant and by CTR. Okay, I have 2 problems with that. Number one's not true. Why isn't it true? Because the application that the planning board reviewed was the application that was first before them on September 14th, 2021. And they spent exactly 7 weeks on it. Held a number of meetings, worked their tails off. I don't doubt that. It was complicated and it wasn't easy. But they were operating on a self-imposed deadline of November 1. And when you're galloping through town, you miss details. And one of them that they miss was the village and what had happened to it. Okay. So first of all, the fact that the planning board spent a lot of time on this in the 7 weeks after September 14th is fine. I don't know why that belongs in our conclusions. And certainly the fact, the statement that it was over a period of 6 months is untrue. I also wonder about the comparison between these people working their tails off and the Board of Appeals just kind of playing with it. I don't like that hint. And I don't mean that it was intentional on Mr. Collier's part, but it's there. On page 4, the last bullet point at the top says the fact that the Acadia Wilderness Village property, as it is currently proposed, is significantly different in ways that are difficult to measure. Absolutely true. I point out how, and I don't think that ought to be changed, but I point out that it incorporates the information that we took judicial notice of, as it should. We have the right to do it, and we did it. It's the end of page 14. There were other changes that Ms. Chow proposed. I haven't looked at them very hard. And I don't intend to carry her water for, but the members might want to look at them. I'm particularly interested in the reference, the quotation from the October 12 transcript before the planning board. I'm sorry. Just a moment. Well, there's a September 21 conversation that Mark Good starts off about the changes. And there's a discussion about it. That's in the record. On October 12th, Mr. Hamilton comments about it too. I'm not going to try to evaluate that. But those are the things that I'm interested in.
James.
Madam Chair, with respect to the judge there, this is the Board of Appeals in rural Maine. I mean, I was in court one time with Dave Sepchak and Chad Smith talking about whether a Great Lake was classified GPA that is over 10 acres, and the judge wouldn't take judicial notice of it. So there's no judicial notice. We're not a bunch of judges. We're a bunch of Board of Appeals members. If Mr. Cohen wants to, or Judge Cohen wants to rewrite Maine law in a way that I'm not understanding of it and go way, way out on a limb somewhere and make you all judges taking judicial notice, which is diving into the deep end of de novo versus appellate and creating all kinds of appeal issues for Mr. Hamilton to deal with, God bless you, go right ahead. My advice to you is simple. What I've tried to do in the thing that I gave you was act like Joe Friday on Dragnet, just the facts, ma'am, just the facts. Just do what the board said. Keep it simple, stupid. Don't say anything controversial. In reference to Ms. Chow, she's, God bless her, representing her client there, trying to get some stuff in, which would be good for her on appeal. And so was Mr. Hamilton. I looked at what they said, and where I thought there was a typo or some obvious good point, I included some small things, I think, from both of them. But not only would it be carrying her water, but it's building an argumentative case to include the stuff that she wanted to put in when she sent it to me, and when she sent it to me again, sent it to the board this afternoon. So I guess I'm at a loss to why the judge wants to go way out on a limb and create more issues on appeal. I think that unless there's a typo in here somewheres or a stunning inaccuracy that I missed, and hey, it's possible, I'm not perfect. But unless you see something like that, I think it's time to wrap this up and go home.
Mike,
I think we've already decided that since both parties to this want this decision vacated, that we should do it. But I would be remiss if I didn't quote medieval philosophers. Abelard quoted St. Anselm as saying, "It's like a man who lights a fire in a room, not to provide warmth and illumination, but to fill the room with smoke." And I got a feeling that we've got rooms full of smoke here, and we're not going to sort it out. I think Attorney Collier was right. We're not judges. We're not experts in the law. And I think, honestly, every one of us knew it was headed outside of us. We have both parties that want it vacated. I don't know a clearer path to happiness than that. I really don't. So I would say we've already voted for it. Let's conclude that we vacate the decision of the planning board and let the rest of it play out. Thank you for listening to me.
yeah, and I don't think anybody is saying that has changed. It's just how we document it. And I think Rick has some issues with the findings of fact and conclusions of law, the document, not the fact that we're going to vacate or not. We have voted on that, and that's clear. So yes, Rick, did you have a
Just the
comment?
last thing is that as long as we understand that our decision is based, at least in part, on the information contained in our own files, and simply not subject to a reasonable dispute, namely the changes in the village, as demonstrated by documents that the AWL applicants created and gave to the CEO, and the CEO approved. That's all I'm talking about.
I'll just
Please
renew
be
my
quiet for a
objection.
minute.
I just renew my objection, Madam Chair. If we're going to talk about AWV again at this meeting, beyond the scope of the findings that have been drawn by Attorney Collier for the benefit of the board's review, I'm going to object to Member Cohen's continuing focus on a project that is not before this board. So I'll leave it there.
Okay, if you had let me finish, Mr. Hamilton, it would have been over.
Madam Chair, if I may.
I am addressing these things not because I want the board to stand on its head and do fancy stuff, but I'm addressing it to the court system that may have to evaluate our work. They'll understand.
All right, thank you, Rick. James?
I just want to reiterate that in case you didn't pick it up in your training, that the tempo, the tenor, I should say, the tenor of what's come out of the law court the last 30 years is to provide reasons so they can understand why you made the decision. Don't make it fancy. And as to discussing the place next door, I agree with Andy. We don't have to. Let's wrap this up.
So Rick, let me, or all members of the board, can we live with first the findings of fact, which is page 1 and 2? Does anybody have any specific edits for that document? Seeing none, hearing none, I'm going to move on then to conclusions of law. Does anybody have any specific suggestions, edits for that document? Seeing none, hearing none, I'm going to finally move on to the decision, just on page 6. And it's the first 3 paragraphs, because below that deals with remanding. Yes,
Yeah.
James.
Can I read what I have now? Because I edited it just a little bit.
Okay, thank you.
So the way it reads now is the first paragraph is the same. The Board of Appeals finds as a matter of law that the appellant has met its burden of proof and that its appeal should be upheld in regard to the planning board's failure to consider Katie Wilderness's Lodge's entire proposal for the 2 facilities and its failure to apply the applicable version of the land use ordinance as amended in the spring of 2021 to the application. So that part's the same. It's just a synopsis in essence of what the board decided. Now, here's where I changed it. This is the same. Specifically, a board member voted at the board's meeting on April 14th, 2022 to quote, to uphold the appeal as discussed and voted on by the board. So that first paragraph is just a summary of that. And then I have it same as it was. Based on the stated findings and conclusions, the appeal of the planning board's decision to approve a plan for a campground is upheld for the reasons stated in the aforestated motions. And the approval of the planning board in regard to this matter is hereby reversed and is hereby vacating. And then I have added, are you ready? I've added very specifically, a board member moved at the board's meeting on May 5, 2022, that, quote, the Board of Appeals upholds the appeal, reverses the decision of the planning board, and vacates the decision of the planning board. I think that's what Mel said. Correct me if I'm wrong.
That's correct.
And then I have changed the last little bit to say, a board member moved at the board's meeting on April 14, 22, that the decision was not final, to allow the Board of Appeals to make its final decision at its next meeting. That's a highly technical thing. So if that all looks good, signature pages follow. I can send it to Jesse, and then you guys can, I can send this final version to Jesse. I can copy Ms. Chow and Andy, and you can filter into the town office and sign at your leisure.
All right. Can we live with that, board members? What James just went through? We can. Okay, that's great. So I think I'll take a motion to accept the findings of fact and conclusions of law as presented by document and with edits by James. I will entertain that motion.
So moved.
Thank
I'll
you,
second.
Mike. Thank you, Mel. Mike moved the motion. Mel seconded. Any further discussion? Great. Hearing none, seeing none. All those in, well, let me do a roll call. Mike?
Mike Hayes, Bass Harbor, yes.
Mel
Mel?
Atherton, Mel Atherton, Bass Harbor, yes.
Rick?
Yes,
Marcia?
Yes.
And I vote yes. So that is unanimous on the statement of findings of fact and conclusions of law. Please, board members, do make your way into the town office as early as tomorrow or Monday, perhaps. Tomorrow's Friday. And there'll be a place for you to sign. Just go to the desk, right, Jesse, or ask for you?
Yep.
Just go to the front desk, and there'll be a place for you to sign. I want to thank my board, who've been amazing, I think, through all of this. Thank all of the parties. And James, thank you very much for your guidance and your help in all of this.
You're welcome.
And I believe this brings this particular hearing to a close. I'll entertain a motion to adjourn.
Madam Chair, before you do, can I just thank the board for its efforts and just note that AWL will be bringing an appeal of your decision shortly, and thank you.
Thank you, Mr. Hamilton.
Madam Chair, I would just also, on behalf of CTR, like to thank the board for all of its very hard work and diligence in this matter, as well as Mr. Collier. Thank you very much.
I have one
Michelle?
last thing. I'd like to thank Joanne for managing this process better than anybody I know. So thank you, Joanne.
Thank you, Mike. I appreciate that. And, I'm getting some thumbs up. Thank you very much, everybody. I appreciate that. This has been difficult. We've taken it very seriously. The board has been amazingly patient and diligent, and that's what our town deserves. It's what it needs, and hopefully we've delivered that, and we'll see where this goes from here. So I will entertain that motion to adjourn now.
So moved.
Thank you, Mike. Do I have a second?
Second.
Thank you, Mel. All those in favor? Raise your hand. Thank you, everybody. The meeting is adjourned.